Do you understand that?
Definitely.
At least in my opinion, I think you're going to be at a significant disadvantage in this case if you attempt to represent yourself with a licensed attorney on the other side.
I already am. I'm dealing with the wolves. There's no fair trial in this military maritime courts. There's nothing fair about it. I mean, you've already made your determination the other day that I was not guilty.
Your Honor, you said something about the jurisdiction. If there's no problem with the jurisdiction, I mean, how come you couldn't tell me exactly which jurisdiction you're operating under? Because I would have to object to what you said. I mean, it don't make no sense to me, Your Honor.
I told you that before, Mr. Matson. I'll tell you again. I'm operating under the jurisdiction of the Michigan Constitution that sets forth.
Welcome to an epic two-part sovereign-style voyage unfolding in Judge Michael Olsaver's courtroom, starring a very stubborn man named Robert Joseph Madsen. We've packaged both parts of this long drawn-out saga for your convenience, complete with timestamps and chapters in the description. In part 1, we find ourselves in Michigan, where Madsen is facing a slew of charges ranging from possession to driving on a suspended license. True to SovCit form, Madsen tries to use the right to travel defense, but Judge Olsaver is having none of it. The judge shuts down his attempt to relitigate arguments that have already been ruled on, leaving this so-called sovereign defendant visibly stumped. In part 2, we're back in Zoom court for Madsen's sentencing hearing, where he has already pled guilty and accepted a plea deal. Yet, in true SovCit fashion, Madsen once again protests the court's authority with his pseudo-legal rhetoric, wasting the court's time. Will his sovereign word salad manage to get him a lighter sentence, or will Judge Olsaver throw the book at him? Stay tuned to find out.
All right, we are on the record then in the matter of the people of the state of Michigan versus Robert Joseph Madsen, file number 21-20513-FH. Today is the date set for an arraignment in this matter. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Meir for the people.
Phoebe Meir on behalf of the people.
James Daly on behalf of the defendant.
All right. We do
I never asked for an attorney. I said I would be representing myself in appropriate persona. This is just one way to railroad me. That's all. Get me in your jurisdiction.
All right. Mr. Daly, maybe you or Ms. Meir, maybe you can fill me in on the status of the...
yes, Your Honor. I remember now. We did have an exam in this matter, and Mr. Madsen did represent himself at the preliminary exam. And then Mr. Madsen, then once it was bound over, did fail to appear here in circuit court. So now that he is incarcerated, whereas before he was not, I guess if we just go through whether or not he wants an attorney or still wants to represent himself, since we have had an exam in this matter, you know, once he makes his intentions known on the record, then we can proceed with him still being pro per. But I would like to go through and make sure he is knowingly making that decision.
All right.
Normally,
okay. Yeah, Mr. Madsen, just let me sort this out a little bit. Mr. Daly, have you been appointed as standby, or what exactly is your status?
I was appointed as standby, Your Honor. Mr. Madsen and we get along fine. He's a pleasant individual to talk to, but he wants absolutely none of my legal input. Basically, he has a theory that I don't believe is justified under the laws of the state of Michigan.
Okay.
And I've indicated that to him.
All right. All right. We are back on the record then in the matter of people versus Robert Madsen. Sir, you are Robert Joseph Madsen, correct?
I am an attorney for the all caps name Robert Joseph Madsen. I am living flesh and blood, human. Upper and lowercase, Robert hyphen Joseph :space Madsen. That is my name.
All right.
As shown on my birth certificate, live birth, that would be me, has understood that the government has taken that name and made an all caps name and tried to be to claim an account over that name, which to do business with.
All right. Sir, do you understand that you have a right to be represented by an attorney in this matter?
I do understand that.
You also understand that if you want an attorney and you can't afford one, that you can tell me that and I would appoint one for you at public expense.
UCC 1-308, all rights reserved. By me answering and speaking to you at this time, doesn't mean that I'm in any way being given any kind of authority over my body to you at this time.
Okay, I will note, sir, your objection to my jurisdiction over you, and I will preserve that for the record. As
Your Honor,
as we discussed in your hearing on Monday, it is my position that this court does have jurisdiction over you, and I am going to proceed as such. And
yes, sir.
Again, your objection is preserved for the record, and if you would like to file an appeal, if that becomes necessary at a later date, you'll have the ability to do that.
Actually, I think I can do something a little quicker. I like to exercise my rights of subrogation, have the prosecutor file my right to subrogation, or certify my right to subrogation at this time. It's an undeniable right. Subrogation is the removal of a third party. It's in the laws, Black Laws Dictionary, 6th edition. Also the Bouvier Law Dictionary, 2nd edition. That the removal of third party would be the prosecutor in this case.
All right.
Black's Law Dictionary is a comprehensive legal dictionary used by lawyers, judges, and law students. Sovereign citizens often cite it, believing that if they can manipulate or selectively quote from this dictionary, they can undermine or challenge legal proceedings. Most sovereign citizens cherry-pick definitions from Black's Law Dictionary in order to support their arguments, taking terms out of context or interpreting them in ways that align with their beliefs. For example, they might refer to outdated or obscure definitions of words like person or citizen to argue that laws don't apply to them. By citing Black's Law Dictionary, sovereign citizens attempt to lend legitimacy to their arguments, hoping that their use of official legal terminology will convince others of their position. However, their understanding and application of these definitions are usually flawed or misleading.
All right. I'll note that request for the record and find that there is no right to subrogation in a criminal matter, and so I'm going to deny that request. Again, your objection will be noted for the record, and if you feel you need to appeal that decision at a later date, you will have the ability to do that. You understand, sir, sir, please let me speak. Do you understand, as I asked earlier, that if you can't afford an attorney and you want one, that the court would appoint one for you at public expense?
Do not want one. Thank you.
Okay.
I am not a U.S. citizen. I am sovereign. Separated myself from the U.S. government back in 2018.
We've covered that objection, Mr. Matson, and I've ruled on it. Again, it's preserved for the record, and you can appeal it to the Michigan Court of Appeals if you would like to do that.
Well, definitely. It's fraud. American jurisprudence guaranteed it's fraud. Yes, it is. I studied it up and down. I know it all too well, so it will go to the Supreme Courts. I promise you.
Okay.
As of right now, I would, for the record, and let the record reflect any objections or denials that you keep denying me, that I'm asking you to file a 1090 an OID 1099 for the prosecutor, because the prosecutor is using my name to do business, and I will prepare the 1096 and the 1099A. So this court proceeding is going to go on and have a jury trial. There's going to be sovereign people, secure party creditors at my status, and also he's going to be filing that OID 1099 for the prosecutor.
Right, sir, do you understand that you've been charged with possession of a controlled substance in this case, and that the maximum penalty for that offense... Sir, I'm going to ask you to let me finish when I'm speaking. I've done the same for you, and I'd ask you to do the same for this.
Your Honor. Yes, sir.
You understand that you've been charged in this case with possession of a controlled substance, cocaine, heroin, or another narcotic of less than 25 grams, that the maximum penalty for that offense is up to 4 years in prison.
I do not understand the nature and the cause of the crime.
All right, I'm advising you at this point that you have been charged with possession of a controlled substance, cocaine, heroin, or another narcotic of less than 25 grams, and that the maximum penalty for that offense is up to 4 years in prison. I'm also advising you that you've been charged with operating on a suspended license. A license has been suspended, revoked, or denied, that there is a second offense notice with that, and therefore the maximum penalty for that offense is up to 1 year in jail and or a $1,000 fine. I'm also advising you that you have been charged in this case with alcohol, open container in a vehicle, and the maximum penalty for that offense is up to 90 days in jail. This also carries a habitual offender second offense notice, which increases the potential penalty to 1.5 times the maximum sentence on the primary offense. As I've indicated, you do have the opportunity to consult with a lawyer if you wanted one, and if you can't afford one, I would appoint one for you at public expense. Mr. Manson, or sir, I believe you've referenced this already, but do you have any training in the law?
Yes, I do.
Would you tell me just a little bit what that training is?
Common law.
Okay, and have you studied that yourself?
Yes, I have, along with a couple other people.
Okay, you understand that the law in this case consists of criminal statutes that you're alleged to violate, the Michigan Court Rules of Criminal Procedure, Michigan Court Rules on Evidence, and any number of decisions from the Michigan Supreme Court and Court of Appeals which interpret those statutes and rules.
I understand that the Michigan Supreme Court offers 2 different types of courts. Common law court and a tribunal military maritime court, which this court is operating under, and they're not operating properly with me at this time.
Right, you understand that the prosecutor that's...
Sorry, go ahead.
You understand that the prosecutor that's going to try this case has been to law school, has had significant education and a number of years of experience and training in the law?
And that's perfectly fine.
All right, do you understand that if you do represent yourself, you're going to be required to follow the Michigan Court Rules and the Rules of Evidence?
I'm going to be operating under common law laws, which that's what I should be under as common law. If this is not a common law court, I don't belong here. All
right, you understand that I know you've made that objection and then made it several times, but I'm going to conduct a trial on this matter that's going to require you to follow the Michigan court rules and the Michigan rules of evidence. You understand that?
Yes, sir.
And you understand that those rules are going to determine whether you can do things like ask certain questions of witnesses, admit documents, photographs, or any other evidence that you might have.
Yes, sir.
You understand that you're going to be responsible for the jury selection process, and that's also governed by court rules, which determine when you can appropriately challenge a witness.
Yes, sir.
Do you understand that in order to become a licensed attorney to practice in Michigan, it typically requires at least 3 years of law school and passing a bar exam to show that you have a sufficient knowledge to work as an attorney?
Not a part of the state of Michigan. I am the Republic of Michigan, Michigan Republic.
Okay, you understand that in order, if you wanted to have a license to practice law in Michigan, you would need to go to law school and pass the bar exam?
No, incorrect.
Okay, you understand that that the attorneys handling your case, the prosecutor is going to have a license to practice law in Michigan that meets the requirements that I've already indicated to you.
Which makes any judge or prosecutor or attorney a part of Great Britain, foreigners, only operating under their foreign sovereign immunity, which actually I have myself and trumps over all years.
All right. Again, I appreciate your objection to this court's jurisdiction, and I've ruled on that. And again, I'm not going to change the ruling. You can appeal that to the Court of Appeals in the Supreme Court if you wish at the appropriate time.
Do that.
Do you understand that at least in my opinion, I think you're going to be at a significant disadvantage in this case if you attempt to represent yourself with having a licensed attorney on the other side?
I already am. I'm dealing with the wolves. There's no fair trial in this military maritime courts. There's nothing fair about it. I mean, you've already made your determination the other day that I was not guilty. Last time I seen you in court. Let the record reflect that. I mean, you sit there and enter the plea and not guilty.
Sir, as I indicated to you at that hearing, I entered a not guilty plea for you. That is not my determination that you are not guilty of what's been alleged.
It's working from the bench, Your Honor. It's not your job to enter a plea. It's mine or my attorney's, which in this case it would be mine. So the court has already made a determination that I am not guilty.
All right. Sir, are you sure that you want to represent yourself knowing all of the disadvantages, or at least what I believe to be the disadvantages that you face?
Yes.
Sovereign citizens believe that by appearing pro se, they are asserting their status as a natural person who is not subject to the same laws and regulations as their legal person or straw man. By using sui juris, they aim to reinforce the idea that they are not subject to the laws and regulations that apply to ordinary citizens. They believe that this status exempts them from following laws, paying taxes, or adhering to court rulings. In reality, none of these terms provide them with any special status or immunity from the law, so their refusal to engage with the legal system in a conventional way often leads to delays, contempt of court charges, and eventually harsher penalties.
And is that decision absolute and unequivocal?
Absolute and unequivocal.
Do you have any hesitation about the fact that you want to
trial will be my peers will be secure party creditors.
Do you have any hesitation?
The jury.
Do you have any hesitation about the fact that you want to represent yourself?
No. No matter what you do to me, I will get out of it, and there will be lawsuits.
All right. At this point, I'm going to determine that Mr. Mattson has made an unequivocal request to represent himself. The right has been asserted knowingly and voluntarily after discussion advising him of the disadvantages of self-representation.
Mr. Daly.
And at this point, I will appoint.
Will Mr. Daly be willing to come over and talk to me here after we get done with this video screen?
All right.
Conference.
Yeah, I will appoint Mr. Daly as a standby counsel. And sir, you're asking.
Can I speak with him about a couple of things?
I can put you in a breakout session so that you can speak to him over video conference privately.
Let me do that, please.
Okay. All right. Mr. Mattson should be back from the breakout session shortly.
Your Honor, I'm going to be going over and talking to Mr. Mattson. I still think, after my discussion with him, there may be some ways to work this out.
Okay. He should be back from the breakout session any second here.
They're back on.
Oh, all right, we do have Mr. Mattson back from the breakout session with Mr. Daly at this point. Mr. Daly, you had indicated to me off the record that you were going to have an in-person meeting with Mr. Mattson at this point. Is that correct?
I will. I can't get that done till Monday, but I've already indicated to him I'll do it on Monday.
Okay. And sir, is that something that you want to do, is have an in-person meeting with Mr. Daly?
Yeah, I want to see if there's something that we can work out here just to save time and hassle and a lot of grief between all of us.
Okay.
But really would like to speak to Mr. Daly one last time before.
All right. Okay, so this is an arraignment. I presume, Mr. Mattson, that you'd like to enter a not guilty plea until you've had an opportunity to speak with Mr. Daly. Is that correct?
Yeah, I'm not entering any plea until I speak with Mr. Daly and he speaks with the prosecutor.
Based on that, I'm going to find that Mr. Mattson stood mute to the charge, and I'll enter a not guilty plea on his behalf. And I'll set this then for a pre-trial.
I object to that, Judge. You cannot enter, that's working from the bench, you cannot enter a not guilty plea on my behalf. Either me or my attorney has to do that. I mean, has the court again made a determination that I'm not guilty?
All right. As I've explained previously, it's not a determination that you're not guilty. It is an entry of a plea based upon your not entering a plea at the arraignment. I will set a pretrial for December 1st at 8 a.m. And that will give time for Mr. Daly to have an in-person meeting with you at the jail.
Can I speak with Mr. Daly here again in private?
I'll just go over to the jail and see him on Monday, Judge.
Okay, he's going to come over to the jail and see you in person on Monday. So you can tell the officer that's with you that you're done in court for today.
Okay, how about next time a bond, PR bond next time I go to court. All right.
With respect to the bond for right now, I'm going to leave it as it's currently set based on prior failure to appear at an arraignment.
I did appear. You wasn't there. I went to the clerk's office, then I went on television screen for Anna Marie's court, and it kept clicking me off for about 45 minutes. And after that, I gave up. How did it appear? I think that's a due process thing.
Now, so we are on the record in the matter of the people of the state of Michigan versus Robert Joseph Mattson, file number 21-20513-FH. Today's the date set for sentencing in this matter. We are proceeding today partially by video conference and partially in person. Mr. Daly is here in person. Mr. Daly, would you like to place your appearance on the record?
James Daly, appearing on behalf of Mr. Mattson.
And we also have Mr. Stevenson with us from the Michigan Department of Corrections. And sir, you are Robert Joseph Mattson, correct?
Well, hey, I'm a living flesh and blood man, attorney for a public officer or statutory citizen judge. I'm a living flesh and blood man.
All right, you are the living flesh and blood man who's known as Robert Mattson, correct?
Attorney for Robert Joseph Mattson, which would be all caps name.
Good morning.
Judge, there was something that I was trying to talk to my attorney about. That before you let me out of the hospital, I was in the hospital or the jail. I was experiencing a lot of pain and trouble. The jail was not treating me properly. After I got out of the jail, I went to the hospital, and they hurried and rushed me to the Toledo Hospital, where I almost died. Had I not been released from jail when I did, I would be dead in that county jail.
All right, Mr. Mattson, we're here for your sentencing hearing today. I'm not really able to address issues of medical treatment while at the jail.
Well, I just think there's something I read to.
Mr. Mattson, don't interrupt me, please. The medical treatment that people receive at the jail is not within my purview, and I'm not going to address that today. So,
well, I just think I'm going to correct my.
Mr. Mattson, do not interrupt me, please. Have you had an opportunity to read and review your pre-sentence report?
I did with the secretary for Mr. Daly.
Have you had an opportunity to discuss your pre-sentence report with Mr. Daly?
I haven't had an opportunity to discuss it with him. I did with his secretary.
My secretary got a hold of him.
Mr. Daly, if you could just let me allow him to finish his answer. What were you saying, Mr. Mattson?
I did with the secretary. I talked to her over the phone and told her everything looked good. And I believe Mr. Daly was supposed to get back a hold of me. I don't know if he got too busy or something else happened.
All right. Thank you, Mr. Mattson. Mr. Daly, you wanted to say something on that issue.
Yes, my secretary contacted him in regards to the PSI. He said everything was right. He had no complaints about anything. I still tried to contact him back, didn't get an answer.
All right. So what we'll do is have, if Mr. Daly, if you'd be willing to step out into the hallway, we have an iPad out there that we can log into the Zoom session. And
I don't think he needs that. He's ready to be sentenced, Your Honor. You have any other questions, Mr. Mattson?
Yeah, Judge, I think the court is making a big mistake here. I've not.
I appreciate that, Mr. Mattson. And we've discussed it.
Any of my rights or immunities. I'm not a statutory citizen. I am sovereign. I'm not somebody who's under the.
Mr. Mattson,
I've never signed anything to.
Mr. Mattson, if you don't stop talking, I'm going to your device. Okay. I've discussed all of these issues with you before.
Okay.
And
well, I object, but I mean,
Mr. Mattson, this is your all right. I've muted Mr. Mattson's device because he won't stop interrupting me. Mr. Mattson, what I'm trying to tell you is that we have discussed these issues before. You've raised those issues. I've ruled against those issues. And ultimately, you pled guilty of your own choice to the controlled substance, possession of narcotic less than 25 grams. And so I'm going to sentence you on that charge today. if you'd like, I will have Mr. Daly step into the hall and you can have a breakout session with him so you can speak with him about your pre-sentence investigation report if you have questions or things that you want to talk with him about regarding that report. So I'm going to unmute your device now, and I want you to tell me whether you want a breakout session with Mr. Daly or not.
Hello?
Yes, we can hear you now. You want a breakout session with Mr. Daly?
Well, I've tried to talk to Mr. Daly before. About
Mr.
this.
Manson, answer my question. Do you want a breakout session with Mr. Daly or not?
Your Honor, you're going to do what you're going to do. I mean, I've tried to talk to the courts and reason with the courts. I mean, if you're going to sentence me today, then I just file for an appeal. I'm an objection to anything that happens today. I was under duress when I took the plea due to my life was at stake.
Mr. Manson, please answer my question. Do you want a breakout session with Mr. Daly or not?
Mr. Daly hasn't been much of help for me, Your Honor. So
that is not an answer to my question, Mr. Manson. Please answer the question. Do you want a breakout session with him or not?
Sorry, Your Honor. It just ain't been doing me any help, no justice at all. I mean, I've already said what I had to say. If the courts is going to sentence me today, then that's what they're going to do. I don't agree with anything that's going on today. I'm sorry. My life was at stake when I had talked to the courts.
All right, Mr. Manson, please stop talking. So you refuse to answer my question about whether you want a breakout session with Mr. Daly or not. The law.
I didn't want
Mr. Manson,
Daly
stop
as my attorney. Yes, sir.
The record, I placed Mr. Manson on mute again because he's continually interrupting me. Mr. Manson, what I'm trying to explain to you is that you have the right to discuss your pre-sentence report with your attorney before the sentencing. I've asked you 4, 5, maybe 6 times now whether you want to have the opportunity for that breakout session, and you won't give me a simple yes or no answer. So what I'm going to do right now is ask Mr. Daly to step into the hallway. We'll set up that iPad. I'm going to put you in a breakout session with Mr. Daly in order to make sure that I comply with with your rights to have that breakout session. So at this point, I'm going to set that up, whether you want it or not, so that we have complied with that requirement.
I just had a repeated conversation you already had. I'm prepared for sentencing.
All right, Mr. Manson, you've now had an opportunity to discuss the pre-sentence report with Mr. Daly. Is that correct?
No, he didn't want to hear me, Your Honor. He just told me that he was here to get me sentenced. I tried to talk to him about things. I tried to talk to him before we even went to court about things that was going on with my life and me about dying, and as far as being incarcerated in jail, which he didn't ever try to help me out, because if he would have did an investigation and known that I was in court and I was wrongfully put in jail. I told him I'm not a statutory citizen. I'm a constitutional citizen. I mean, he don't care to do anything to help me. All he cares about is just helping you guys out and get me sucked into the system. And it's wrong.
All right. For the record, I did provide Mr. Manson with an opportunity with Mr. Daly in a breakout session. Mr. Manson.
Yes, sir.
Satisfied with Mr. Daly and the advice that he's given you?
I'm not satisfied with the advice he's giving me, no, sir.
Do you wish to explain or challenge the accuracy or the relevancy of any of the information that's in your pre-sentence report?
The stuff that's in the pre-sentence report is directed to a statutory citizen. I'm not a statutory citizen. I'm a constitutional citizen. You cannot be a constitutional person and a statutory person at the same time, Your Honor. You have to be constitutional rights, which the court's designed to protect rights. So I was asking you, Judge, are you working as a banker or judge today? I mean, there's nothing to show that there's even a, I mean, is there anything to show that there's even a contract between us? I mean, is there...
The contract theory. Sovereign citizens often assert that all interactions with the government are voluntary and contractual. They view laws, regulations, and enforcement actions as offers to contract, which they believe they have the right to accept, reject, or negotiate. When they receive a traffic citation, they interpret it as the government offering a contract, which they can refuse by not engaging with it. Sovereign citizens believe that receiving a traffic citation or any other government-issued document is an attempt by the government to enter into a contract with them. This belief stems from their broader misunderstanding and misinterpretation of legal concepts, particularly those related to contracts and individual sovereignty. The right not to contract. Sovereign citizens mistakenly believe that by refusing to contract with the government, they can avoid legal obligations. They argue that since they never explicitly agreed to follow certain laws, like traffic laws, they are not bound by them unless they consent. This notion is rooted in their misunderstanding of how laws work, as they fail to recognize that laws are not optional contracts, but rather enforceable rules that apply to everyone within a jurisdiction. The belief in the right not to contract is part of a broader sovereign citizen ideology that seeks to reject government authority by misconstruing legal principles, ultimately leading to misunderstandings and legal troubles.
This isn't a contract issue, Mr. Matson. It's a criminal law issue.
For the time to exist, there must be an injured party. Is there an injured party? I mean, in the constitutional rights, Share versus Cohen, 481 F 945. In order for there to be a crime, there ought to be an injured party. If there's no injured party, there's no crime.
All right, Mr. Matson, you're arguing the basis of your conviction. Again, you pled guilty to this charge. What I'm asking you is whether, Mr. Matson, what I'm asking you is whether you'd wish to explain or challenge the accuracy or the relevancy of any of the information that is in your pre-sentence report. So is any of that information inaccurate?
Inaccurate as far as the person that reports they're trying to sentence an all caps name. It's not me. I'm a living flesh and blood man. You're after a fictional person.
All right. So with respect to that argument, what the court will say is that I will leave the information that is in the pre-sentence report in the pre-sentence report and deny what seems to be some kind of a request to modify the pre-sentence report based on an argument that doesn't state any cognizable legal theory about a difference between Mr. Matson as a human being and Mr. Matson as something else. So the pre-sentence report will stand.
Well, you never even explained to me what the jurisdiction was. I tried from the beginning that
Mr. Matson, all right. I'm going to mute Mr. Matson again because he continues to interrupt me with a line of argument that I don't even know what to say about it. It just is, it's not a legal argument at all. It is some kind of fanciful belief that there's a difference between Mr. Matson, the human being, and Mr. Matson as some other entity, which is not recognized by the law, and I'm not going to entertain it any further. Mr. Daly, does the pre-sentence report disclose any prior convictions in which there exist any known constitutional defects?
No, Your Honor.
The probation officers calculated the minimum sentencing guidelines in this case to be from 0 to 9 months. Do you agree with that computation of guidelines?
Your Honor. I do.
Thank you. Before the court passes sentence, Mr. Daly, is there anything you'd like to say on behalf of Mr. Matson?
I've had the same conversations with Mr. Madsen the courts have. He's never wanted to talk about this case. He's always wanted to talk about what he perceived are constitutional issues. He pled guilty. He knew what he was doing. I do know that. I'm prepared to complete the sentencing now.
All right, Mr. Madsen, in a moment, I'm going to unmute your microphone and I'm going to give you an opportunity for allocution. That's an opportunity to say anything that you'd like to say on your own behalf before the court passes sentence.
Yes, sir. Can you hear me?
Is there anything you'd like to say on your own behalf?
You said that. I can say anything that I wish before sentencing.
You can.
I'm sorry, sir?
You can.
Okay. Yes, sir. Your Honor, I mean, before I took that plea, I told Mr. Daly that I wanted to sit there. I wanted him to sit there, get the cameras for the courts to prove that I was at the court date the day that I was put in jail, and said that I wasn't in the court for a contempt of court. He said, and I told him I wanted to fight my case, but I had to be out because I had medical issues. Mr. Daly said that's fine and all, but if you stay here and you fight this case, they'll keep you in here for a year fighting your case. You will not be let out of jail. Your Honor, I couldn't do that. I was in major pain. I would have died in that jail. My proof is within the doctor's records in the hospital. I had a serious condition which would have left me dead within a week from the time that I took the plea. The following day after I got up, my wife was killed in a car accident. Because everything's been going downhill for me ever since. And now this with the courts. I don't feel that I've had a fair chance with the courts ever since I even started with the courts, because the courts has not proven jurisdiction to me. I've not written any papers out agreeing in the contract saying that the courts can have any kind of jurisdiction over me. I have not relinquished any sovereign immunities that I have. I just don't feel that there's been anything fair, which is not going to be within the court system. I mean, I've tried to say I'm not a statutory person who is within your jurisdiction. If anything, I'd be considered constitutional, but I'm not even under the constitutional laws, but I will use them if I feel necessary as a constitutional living flesh and blood man. There is no injured party. The only injured party would be the state's laws, which the state cannot be the prosecutor, the injured party, and the judge. There's nothing right. The court case either had been dismissed or moved to higher courts. And I wasn't going to sit there and be left in jail to fight my case for a year. I would have been dead. I'd have been stupid not to sit there and just agree with a plea that I didn't even agree with in the first place just to save my life. I don't think it's fair at all. It's not right. There's nothing but wrong here. It's injustice, not justice. I mean, the requirement for equal protection, I mean, treatment is Form 05.0333. The terms are binding you and me together, Judge. There's nothing even sitting there stating that. I mean, you can't be a constitutional person and a statutory person at the same time. Either you're one or the other, and as constitutional rights is known in form number 10.002, and then your context, you have your statutory privilege form would be 0.0503. If you claim your privilege, statutory privileges, you surrender constitutional rights, which I'm not doing any of that. The definition of a public jurist is therefore deception, which is in form 05.014. I've not had time to get my own paperwork together due to the hospital when I logged into their system because my Wi-Fi wasn't working properly on my computer. I couldn't drop my own paperwork. I've been in nothing but severe pain. I've been able to move around and do much of anything for myself. I mean, I just don't feel that anything here is being done today is right, and it's not within the constitutional or the Bill of Rights. It's common law would permit. And if I ask you if you're working under the oath of office or as baker, you don't answer that. You don't tell me which jurisdiction we're under. I mean, these are all important things. I mean, for me to even provide an intelligent argument for myself, I have to know these things. It's guaranteed in the Constitution. I didn't even ask for this attorney. You assume that I didn't know the laws and that I needed an attorney. The attorney has done nothing for me but sit there and try to feed me to the system. The only system that I know is God and God's laws, Judge. If I sit there and swear an oath, because I've never taken an oath to any governmental laws. I'm not a public officer. The only one I've ever taken an oath to is God Almighty Himself. There's only one lawgiver, one creator, one judge. That's God Almighty. That's who I recognize. For me to sit there and agree to anything more than that would be me sitting there violating the laws of my God.
All right. In determining the appropriate sentence in this case, the court has considered the seriousness of your offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what's been said on the record here this morning. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. As indicated, with respect to these sovereign citizen or whatever the other arguments you're making are, we've dealt with the jurisdiction issue in the past. I've ruled on that on at least one occasion, probably multiple occasions, and that ruling's not going to change. You will have appellate rights if you want to pursue those. You're welcome to do that, but you have pled guilty in this case. You indicated during your guilty plea that you were not under any threats or promises or anything like that. And you indicated that it was your own choice to plead guilty. So the court's going to proceed with sentencing in this matter. The recommendation from your probation officer is that you serve 1 year of probation with credit for 29 days that you've served on this case. And that is, I think under normal circumstances, that would be an adequate recommendation with, he's gone.
A few moments later.
We have everyone back with us now. Mr. Madsen, we are in a court proceeding right now, and so I'm going to ask you not to eat anything and to remove your hood, please. All right, I'm going to ask you to remove your hood also, Mr. Madsen. Thank you. So we had been through the sentencing procedure. I had given Mr. Madsen an opportunity at allocution and was starting to announce the sentence. And so I will continue with where we left off. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what's been said on the record here this morning. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law. and the protection of society. Mr. Mattson pled guilty to 1 count of controlled substance, attempted possession of cocaine, heroin, or another narcotic of less than 25 grams, pursuant to a plea agreement which dismissed 1 count of possession of cocaine, heroin, or another narcotic, dismissed 1 count of driving the license suspended, and 1 count of alcohol open container. I believe, am I correct, Mr. Daly, there was there a Killebrew agreement in this case to no upfront jail?
I believe there was a Killebrew in this agreement, Your Honor.
I'm sorry, Mr. Daly, was that a yes or a no?
No.
Okay. So the agreement was to 1 count of attempted possession of a controlled substance, dismissal of the remaining charges, and that was apparently incorrect. There was no sentencing agreement in this case. This is Mr. Mattson's first felony conviction. He does have 4 prior misdemeanors. Those are all from 2015 or earlier. He has 2 2015 cases and 2002 and 2001. And so the recommendation in this case from the probation officer is for a period of 1 year of probation. And I think that, well, it also, I should say, includes restrictions on alcoholic beverages and substance use. And I think that those provisions of terms of probation are appropriate given Mr. Mattson's Compass Needs Assessment scores. He did rate as highly probable in the categories of substance abuse, family criminality, residential instability, and social environment. He does have a substance abuse history of cocaine, fentanyl, painkillers since 2005. I think that it is appropriate to try to get Mr. Mattson some help for his substance abuse problems. The concern I have in this case is that is whether or not Mr. Mattson is going to be willing to comply with the terms of his probation. He has, in numerous court hearings in this case, made a number of what he believes are constitutional and jurisdictional arguments that have absolutely no legal merit whatsoever. And he continued to challenge the court's jurisdiction here this morning. I understand that that may be an honest belief that Mr. Mattson has. And I don't know where it comes from, but I will say Mr. Mattson would be far better off taking legal advice from Mr. Daly than from wherever it is that you're getting it to make you believe these arguments, because as I've ruled repeatedly, there's just no merit to them. They're not rational or coherent arguments under the law. And the concern that that raises with me is that Mr. Mattson, if he does not believe this court has jurisdiction, why then would he follow the terms of his probation? And so if that's the question, then the question I have to ask myself is why would I put him on probation if there doesn't seem to be any indication that he would follow the terms of the probation? The other side of that coin is that I think a lot of this stems from Mr. Mattson's substance abuse issues, and the better way to get him help for his substance abuse issues is to put him on probation and get him into some kind of services to help him deal with that. So ultimately, Mr. Mattson, I'm going to give you a chance at probation, and I hope that you are willing to comply with the requirements that are outlined in terms of your probation, which I'll read to you word for word in a moment so that you're aware of them. If you choose not to comply for the reasons you've stated or any other reasons, you can rest assured you're going to find yourself in violation of the terms of your probation. And then I am going to be imposing other penalties, meaning for you jail time. And I'll just tell you now, it'll be a short leash, because if we continue down this road, I'm already suspect of your ability to comply. So any violations are just going to confirm that for me, and you're going to find that I'm going to lose my willingness to give you a chance. So it will be the sentence of the court that you serve a period of probation for 1 year, that you serve 29 days in the Lenawee County Jail with credit for 29 days served. You must not use or possess alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site, unless the field agent has first given you written permission for your employment at a specific location. You must comply with the requirements of drug and alcohol testing as directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. And you must present proper identification at the time of testing. You must pay the cost of your substance abuse testing. You must not be in possession. You must not use or possess any controlled substances or drug paraphernalia unless prescribed to you by a licensed physician. And you must not be with anyone that you know to possess those items. You must complete an outpatient or residential substance abuse treatment when you are referred by the field agent. You must complete a substance abuse assessment when you are referred by the field agent. You must pay a $30 per month supervision fee, so long as there's no electronic monitoring. If electronic monitoring becomes necessary, that fee increases to $60 per month. You must also pay court costs of $750, an attorney fee of $450, a crime victims' rights fee of $130, and $68 state costs. You do, Mr. Manson, have the ability to request an appeal of your sentence. We're going to send to you 3 copies of a notice of right to appellate review and request for appointment of attorney form. We ask that you sign 1 copy of that form and mail it back to the court. That indicates that you received your copies of the form. If you want to appeal your sentence, you need to fill out the other copies of the forms and mail those to the address listed in those forms within 42 days. Do you understand that, Mr. Manson?
Yes, I do. Hey, Judge, I just had a couple questions, if I may, from you, concerning what you just said.
All right. What's your question?
Well, if there's a crime victims fee, I'd like to know where the victim is, and also, Your Honor, you said something about the jurisdiction. If there's no problem with the jurisdiction, I mean, how come you couldn't tell me exactly which jurisdiction you're operating under? Because I would have to object to what you said. I mean, it don't make no sense to me, Your Honor.
I told you that before, Mr. Manson. I'll tell you again. I'm operating under the jurisdiction of the Michigan Constitution that sets forth the fact that the state has various circuit courts. I'm the judge of one of those circuit courts, that one be where you were alleged to have committed this crime and where you pled guilty to this crime. As far as the crime victims' rights fee, that is assessed in every case where there is a guilty plea or verdict. That is done pursuant to statute that was enacted by the Michigan legislature, and it is required to be imposed here. So that is why I did it.
Several months later.
Welcome back for an update on the precarious saga of the sovereign living man, Robert Joseph Madsen, back again in Judge Olsaver's courtroom. This is the 3rd installment in a case that just keeps getting more interesting. If you watched our last upload with this rude SovCit, then you'll remember the sentencing hearing in part 2, where Judge Olsaver expressed serious concerns about Madsen's ability to comply with the terms of his probation. Well, it's been a few months, and it seems like Mr. Madsen didn't heed those warnings because he's right back in court, and it's for a probation violation. Will Judge Olsaver offer this sovereign man another chance at freedom, or will Madsen's defiance and petulance finally catch up with him? Stay tuned to find out.
We are on the record in file 21-20513-FH, People versus Robert Joseph Madsen. We are here today for a hearing on a probation violation, and we are proceeding today by video conference. Mr. Madsen is present from the Lenawee County Jail. Mr. Madsen, my court notes indicated that at the last hearing you waived your right to be represented by an attorney. I am required to advise you at all stages of the proceeding that you do have a right to be represented by an attorney, and if you can't afford an attorney, the court will appoint one for you at public expense. Do you understand that?
I don't think you'd be violating your oath of office, Your Honor, by allowing me to the right to fighting clause.
Sir, I didn't ask you about any of that. I asked you if you understand.
However,
Mr. Madsen, don't interrupt me. The question I asked you is whether you understand that you have the right to be represented by an attorney.
I do understand I have a right to be represented by an attorney or not. Yes, sir.
Okay.
Sovereign citizens often refuse to admit that they understand anything because they take the word understand literally, interpreting it to mean stand under or be subordinate to someone or something. This tactic is part of a broader strategy to reject the court's jurisdiction. Sovereign citizens often engage in various linguistic tricks in an attempt to avoid acknowledging the court's authority over them. By refusing to say they understand, they believe they are avoiding any admission that could be construed as accepting the court's power.
Okay. You've previously waived that right. As I said, I have to advise you that at every stage of the hearing. So I have to ask you again, would you like to be represented by an attorney at this point?
As I started to say, Your Honor, I don't want the representation. However, I will use the help of handling paperwork due to my means here and having access to certain things in paperwork. I will use your court-appointed attorneys just to help with some paperwork.
Okay, so you don't have a right to have the public defender's office do your paperwork or handle any of that. You have the right to have them represent you or not represent you. So that is your choice.
Not represent me, that's fine then.
All right. So you've previously been arraigned on the probation violation. Do you know how you want to proceed? So your options are you can plead to it if you want, which means you'd be admitting guilt. The other option is that I can set it for a hearing and we can have a hearing on the matter, and then I'll decide based on the evidence submitted at that hearing.
Your Honor, all due respect, I wish, are you working under oath of office today, sir?
Sir, I'm not going to answer these questions or deal with this. We've dealt with you before and your sovereign citizen arguments. I've rejected them all. Sir, do not interrupt me. Do you want to have a hearing or do you want to plead?
I'll take your silence under your oath, Your Honor.
Okay. Do you want to have a hearing or do you want to plead?
I want the hearing. I want to go to trial. I want to go within 90 days to a trial or sooner.
All right. So Sierra will need about a 1 hour hearing on a probation violation.
As well as I'd like you to have the arresting officers that arrested me on that day. I would like their sergeant to be dressed in uniform and at that trial on that day as well, please.
Judge, is tomorrow too soon?
That is probably going to be too soon, yes. Mr. Madsen, do you want to be present in person for that hearing or do you want to do it by Zoom?
It doesn't matter. Judge, whichever is best. for the courts to be fine with me.
All right. I think it will go more smoothly if you are here in person. So we will have you in person here from.
The hearing is going to be on that day.
So you've been charged with a violation of the terms of your probation.
Yeah.
For failing to report. So the hearing is going to be to determine whether or not you failed to report.
Okay, so it's going to be the trial that day.
Correct.
Okay, can I have the state police sergeant there at that trial?
What state police sergeant?
The state police sergeant of the arresting officers on the night of my arrest.
Who are the arresting officers?
I don't remember the exact names, but any state police sergeant in uniform would do.
Why do you want any state police sergeant to be present at the trial?
Just to show how arrests are made, and why they're made, and how they do the determination how they bring people into jail.
Well, how is any of that relevant to whether or not you violated the terms of probation?
I believe there's a lot of relevancy there. I don't see where any of it's going to affect the courts in any way, shape, or form.
All right. So the issue that the court is going to determine has nothing to do with things that happened during your arrest. The issue is whether or not.
It's not about the arrest. It's about the arrest for the violation of probation as well.
All right. The only issue before the court that day is going to be whether or not you reported. So your arrest doesn't have any relevancy to that. So I'm not going to.
I beg to differ, Your Honor. I beg to differ because the jury is going to be a jury of my peers, and at this time,
sir,
you're not going to have a jury of my peers.
Sir, there's not going to be any jury. You're not entitled to a jury trial on a hearing about violating your probation.
I'm sorry, I misunderstood. I'm pretty sure that last time I spoke to you, you said that I had the right to a jury trial for determining if I was guilty for a violation of probation.
I've never seen you on this violation of probation.
I've seen you, or I've seen you just the other day, last week.
No, you didn't. A different judge conducted that hearing.
You're Michael Olsaver, aren't you? There was Sloan, and then there was you. I've seen both of you.
You did not see me last week.
I did.
And so you're not entitled to a jury trial on a probation violation. So again, we will have you back in person on.
Well, hold up then. So if I'm not entitled to a trial to determine if I'm guilty or not, this is a criminal court, isn't it?
It's a criminal court where you have already pled guilty to a felony and been placed on probation.
Because I was at risk of dying in this.
I've muted Mr. Matson's device because he continues to interrupt me and not let me finish what I'm saying. Mr. Matson, I was saying that this is a criminal court wherein you have pled guilty to possessing a controlled substance, and you were placed on probation. As a result of that, your sentence was to be placed on probation. Subsequent to being sentenced to probation, there was an allegation that you failed to report in accordance with the terms of your probation. That is an alleged violation of probation. There's no right to a jury trial for a violation of probation, so the court will conduct.
Let me speak to.
I muted Mr. Matson again because he unmuted himself and interrupted me. We will have you back on April 8th at 3:30, Mr. Matson. This hearing is concluded.
All comments, viewpoints, interpretations, and insights expressed in this video are for education and entertainment purposes. All individuals featured in the video are to be presumed innocent until proven guilty in a court of law. Please do not attempt to contact, locate, or engage with any individuals featured in the video. All comments, viewpoints, interpretations, and insights expressed in this video are for education and entertainment purposes. All individuals featured in the video are to be presumed innocent until proven guilty in a court of law. Please do not attempt to contact, locate, or engage with any individuals featured in the video.